Hello and everybody, and welcome to yet another episode of Law Scope. I'm Sana. I'm the legal expert for Law Scope for Hitbullseye, and in today's video we shall be discussing the PoSH Acts. Basically, we shall be discussing the Supreme Court guidelines with respect to the PoSH Act, that is the Prevention of Sexual Harassment Act. So, essentially, if we talk about certain recent events, first of all, the PoSH Act, that is the Prevention of Sexual Harassment Against Women Act of 2013, has recently completed 10 years of its implementation. And at the same time, unfortunately, one more thing has happened, that a lot of sexual harassment incidents have come to light. Most recently, with respect to the BJP MP from the member of Lok Sabha, Brij Bhushan, who was also the chairperson of the Wrestling Federation of India, has been there are certain allegations which have been leveled against him, and these allegations are basically certain wrestlers and certain reputed wrestlers have made certain allegations against him. Now, when the Supreme Court took notice of these issues and certain other issues which had been coming in front of the Supreme Court realized that there's a need for some guidelines, there's a need of some recommendations to be given to the central government as well as the state government and other private places as well, in order to ensure that the PoSH Act is properly implemented. So, in the light of the same, today we are going to discuss what the PoSH Act entails. So, essentially, if we talk about the the purpose, the intention of the legislation, we have to go back in the 1990s, that is back in 1992, the case of Bhavri Devi happened. So, in Bhavri Devi's case, Bhavri Devi was a woman who was working with the Women's Development Association. Basically, it was an NGO which was working for child marriages, to stop child marriages. She was working in Rajasthan, and one such day when she went on her job, basically when she went as a part of her job to stop a marriage of a one-year-old girl child, then she was essentially she was successful in stopping the marriage, but at the same time when she was coming back, she was stopped by 5 men of the society of the village, who did not like her job that much, and with that patriarchal view, they gang raped her in retribution. That led to a lot of reaction amongst the people, amongst the masses of the country, and eventually it led to the filing of a PIL, a public interest litigation, by an NGO called Vishakha, which gave rise to Vishakha guidelines, that is Vishakha versus the state of Rajasthan guidelines, the very well known guidelines of 1997. So, these guidelines essentially formed the basis of the PoSH Act, and they stated that firstly, there should be like an internal committee which should be made in order to prevent and safeguard the workplaces. It should be workplaces should have complaint committee and counselors as well, and these committees must be basically headed by women. Complaint proceedings should be time bound, they should be expedient, and women are not to be discriminated in any form at workplace during this process of investigation. And there should be maintenance of confidentiality throughout the inquiry whenever a woman complains about any kind of sexual harassment at workplace. So, in this regard, we need to first of all know what a workplace entails. So, firstly, the workplace, the Supreme Court and subsequently the PoSH Act gave a very wide meaning to the word workplace. It stated that not only a workplace can be a government place, but it can also be a private place as well. And not only can it be a private place which is in the organized sector, because we have to agree to the fact that almost 80% of the workforce and 80% of the women workforce works in unorganized sector, and we cannot relegate the act only to the organized sector, otherwise the purpose of the legislation would be defeated. So, firstly, the workplace would include any department or any unit basically of the central government or the state government or any other local authority. So, this is with respect to the government agencies, and secondly with respect to any private agencies as well, where the person is working in private capacity. Second, any hospitals or nursing homes, any sports institutes, stadiums, sports complex, or any competition or games venue. This is with respect to the current ongoing wrestling basically issue, the protests. Whether residential or not, used for training, sports, or other activities. Any place that is visited by an employee also in the course of their employment, and any dwelling place or even a house. So even the domestic help that is working in a house is also covered in this case. And also one point that you might have noted in this point, essentially, wherever a woman is going when she's doing her field work, so essentially, who can she file a complaint against? She can file a complaint against her, basically the employer, the boss, anyone who she has to report to, the team leader, any colleague, any person who's inferior in position to her, any person who's not even working in the office, but she's getting to know that person through the office, basically during the course of her duties, during the course of her employment, for example a client. And even widening the ambit further, the act also states that not only the clients but also, for example, in the case of Bhavri Devi, she was basically not dealing with the client. The perpetrators were not the client, but the perpetrators were certain other persons who she happened to interact with during her job. So essentially, even those people would be included in the same. So now let us try to understand what is sexual harassment means, basically, first of all in the IPC context, and then we'll see how the PoSH Act has widened the concept of sexual harassment under this act. So firstly, under IPC also, if we talk about sexual harassment under 354 clause A, basically 354A of IPC. This was also added through the 2013 amendment, the same time where PoSH was introduced. So it included any physical contact or advances, any demand or request for sexual favor, sexually colored remarks, showing pornography, and any other unwelcome physical, verbal or non-verbal conduct of any of this nature, basically. So this is a very summarized, very concise definition of sexual harassment, which is essentially given in the IPC only. Now, further, the Central Ministry has given has basically released a handbook in which it has explained sexual harassment further, stating that any sexually suggestive remarks or any innuendos, any repeated offensive comments, remarks, inappropriate questions, or any remarks about a person's personal life, any display of any sexist or offensive pictures, which can be in any format, which can be in MMS and posters and SMS or WhatsApp, etc. Anything, any intimidation, threats, blackmailing, or asking for any kind of favors of sexual nature. Then any kind of threats, intimidation, anything, any unwelcome social invitation with sexual overtones, commonly seen as flirting, and any unwelcome sexual advances. Basically, the concept, the idea here is that the consent of the woman is not there, and the woman is basically being taken advantage of in the workplace. Now further, this definition of sexual harassment has been expanded by the 2013 Act in order to include any implied or implicit promise of preferential basically employment, any threat of detrimental treatment, any threat about the complainant's present or future employment status, any complainant's work or creating an offensive or hostile work environment, or any humiliating treatment to the complainant which is affecting her health or safety. So now, why has this definition been extended from the what is given under 2013 amendments of the IPC? The reason is that if there is anything that is falling under essentially this definition of 2013 IPC, then the person can directly go to the police and directly get his or her case registered essentially. However, we also see that it is not only enough that a woman is able to go to the police in order if some kind of a sexual harassment takes place. It is also important, and it is also an incumbent duty of the workplaces to ensure that no kind of taking advantage of a woman is taking place in the workplace. So certain safeguards are also required to be put in a workplace to in order to ensure that none of these things are happening in even in a clandestine way. So if we say that a lot of times a lot of people are not able to prove beyond reasonable doubt that an offense has taken place, so they're not able to file a criminal complaint per se. But in such a case where there's a preponderance of probabilities also that something of this sort is happening, then it is the duty of the organization, it is the duty of the office, it is the duty of that particular employer to make sure that none of these things are happening and the workplace is safe and the workplace is free from any kind of sexual harassment. Because again, stating that most of the times these things happen in a clandestine way, most of the times it has been seen that these things happen by a person who's the reporting senior or the team leader, or can take advantage of a woman in certain situations which are not very explicit but are implicit. For example, withholding promotions or giving that kind of work which if she denies for any kind of favors, she will not be she will basically have to undergo some kind of detriment in her profession. So this is why the definition of sexual harassment has been broadened in this case. So now let us try to understand the 5 key steps for compliance of Sexual Harassment of Women at Workplace Act of 2013. First of all, creation and implementation of an anti-sexual harassment policy. Secondly, constituting of an internal complaints committee and giving them basically a necessary efficiency. So now under this act, it contemplates 2 things. First of all, as we discussed that this act is an act which is contemplated to not only work for the organized sector, but it is also contemplated to work for the unorganized sector, which is 80% of our workforce. So here it has been seen that if a person falls under the organized sector, that is if there are more than 10 employees, then every office, every basically organized sector, every unit has to have an internal complaint committee. And if any person falls under the unorganized unit, for example less than 10 people are working in a certain office, or there is basically a person is working in somebody else's house, in a dwelling house, as a say domestic help. So basically in this case, what every district officer is going to do is he is going to constitute a local complaints committee. This local complaints committee is going to comprise of 4 people. One is going to be the chairperson, second a member, thirdly a person from any NGO and having 5 years of experience, and fourthly a person who is an ex officio member of the committee. So this is what the district complaints committee is going to, the district officer is going to constitute, and any person having a complaint in the unorganized sector can approach this committee, the LCC, in order of any to address any grievance. Now, if a person is working in an organized sector, then he can go to the internal complaints committee of his own office. This internal complaints committee shall consist of 1 a presiding member, 2 other members, and 1 another person who shall be external member, that is who shall be not from the office itself but shall be from any other place which shall be an NGO, and also should be having more than 5 year or more than 5 year of experience. Now, it has to be taken care that the chairperson or the presiding member of the internal complaint committee or the local complaint committee will always be a member, and at least including her, there are going to be at least 2 members who are going to be women in that committee. Now, how that committee is basically going to work, we shall be discussing subsequently. Next is that there are going to be employee awareness and assistance programs. So posters, notices, etc. should be kept in order to make the employees aware that in case they are facing anything of this nature, they they have a remedy basically. And fifthly, statutory annual report filing. So every organized sector, every person in the organized sector who has an ICC constituted, that is an internal complaint committee constituted, has to file an audit report with the district officer every year. So this is a basically a compliance filing, and if you fail to either basically constitute an ICC, or either or you fail to file an audit report showing the number of complaints that have been lodged with the ICC, or what are the workings of the ICC, in that case 50,000 rupees of fine is going to be basically levied on that particular organization, and an enhanced fine shall be levied on that organization in case if it is a repeated offense. Now let us discuss the procedure. The procedure, first of all, any person can complain to the ICC. Here we are only talking about the internal complaints committee, and the same procedure is going to be essentially followed with the local complaints committee as well. Here we are talking about the organized sector. So if any person who feels that she is aggrieved by any certain person, basically she can complain, or any person who's aware of any certain circumstances to have occurred in the workplace, even they can complain. So only the victim does not have to complain, any person who's aware of circumstances can complain, and the complaint has to be essentially made within 3 months of the happening of that particular event. And even if there is a slight delay, then a sufficient cause should be given by the victim or the person who's lodging the complaint with the ICC as to why that inordinate delay took place. Secondly, the ICC is to decide the genuineness of what the complaint is. So the ICC will be given 30 days, and in those 30 days it has to determine whether even the complaint looks genuine, whether it has any cause of action, whether it has any meat to it or not. Secondly, it is going to, for that purpose, it is essentially going to hold an inquiry, and if it feels that it needs to proceed further even after the inquiry, then it is going to hold an investigation. So now when it is going to hold an investigation, it has been given certain powers of a civil court, which is to summon first of all the person who has been accused, any person who is a witness to that event, and any document or any proof that is to be led by either the complainant or the respondent party. So it is kind of going to hold a mini trial of sorts, and to determine whether the respondent is guilty or not. Eventually, once the investigation is finished, the ICC is going to file a report to the management, to the employer, the management whatsoever, within 10 days of the closure of the investigation, and the management is going to decide what action is to be taken against that person within 60 days of receipt of that particular report. Now, when the inquiry and the investigation is going on against a person, it basically the respondent and the complainant, both we have to see that they're working at in the same workplace, and it is also important to make sure that the woman is not undergoing further harassment because of the fact that first of all that she does not have that much of influence as much as the respondent has, or they're still interacting with each other. So there are certain safeguards that are going to be followed. First of all, it has to be made sure that the women and the men are not communicating because of the nature of work or the nature of job profiles they have. So for example, if the man was the reporting senior of the woman must be made to report to somebody else, and there should not be any performance appraisal, performance check, etc. that is to be done by the respondent of the complainant. Secondly, if it is possible, if no interaction has to take place, then paid leave of 3 months. 3 months is the 90 days in which the inquiry and the investigation is going to take place. A paid leave of 3 months can be given to the woman. And secondly, in case there are a lot of branches, say, of that particular office, then the man can be deputed to any other office, so that there is no connection, or there is no basically overlapping of paths between the complainant and the respondent. And if there are subsequently after that, once a report is filed and the management is required to take the decision with regards to what is to be done if they find that the person is guilty, that is, the respondent is guilty. Now, if they hold that the respondent is guilty for some kind of conduct of sexual harassment, then first of all, they can reprimand the person. Essentially, they can reprimand the person, they can admonish the person, they can warn the person, or they can ask the person to write an apology letter to the woman. They can also ask for certain, they can also cut his essentially salary and give that salary to the woman in order to take care of her basically any medical, any expenses of any sort. Secondly, they are going to ensure that the person goes under any kind of counseling. If any kind of therapy or any kind of counseling is required for the woman also, they're going to ensure that that reaches that person. And also, if the case is so aggravated, then the person can also be terminated from services. Also, if they feel, if the internal complaint committee feels that the woman has not filed an FIR, then the internal complaint committee can also ask the employer to file an FIR if the incident is so aggravated. So, these are all the remedies that are given essentially to the woman who's the victim of the instance. However, if in case it is found out that it was a malicious prosecution or it was a false complaint which was filed against the man, in that case also the remedy has been given under section 17 of the Act, which states that the remedies are essentially going to be very similar remedies in nature, which are basically implemented against the man. So if it is found out that it was a false complaint, then the woman can also be admonished, asked the person to write an apology letter. She can be reprimanded, she can be some salary could be cut from her end and given to the man, and her censure could take place, her basically appraisal in her promotion could be stopped, or she can be even terminated from services if she's creating a bad environment. So essentially all these things can take place, whatever can take place against the man if he's guilty of sexual harassment conduct. It can also take place against a woman if she's guilty of false allegations of sexual conduct. So now, having done what basically the PoSH Act entails, now we shall be discussing recent basically judgments by the Supreme Court or other tribunals with regards to the PoSH Act. First of all, in Johnny Ribeiro versus the Union of India, the Supreme Court categorically stated that under Rule 7(6) of the sexual harassment rules, basically, it has been stated that when the inquiry or the investigation is going on in front of the ICC, see, ICC, the people are employees of that office only, and they're not essentially judges of any sort. So a person cannot be represented by legal practitioner. So he has to appear himself in front of the ICC, and he cannot make other people or legal practitioners appear for him or in lieu of him. Secondly, a very important question arose with respect to the liability of online aggregators. So sometimes we see that online aggregators such as Uber, Ola, Swiggy, Zomato, etc., they try to evade their responsibility with respect to the labor laws, and as well as some other laws also which are important for statutory compliances. So essentially, online aggregators, what they do is they get into contracts with certain people that they call their partners. So essentially, delivery partners, drivers, the auto drivers, the cab drivers, etc., they get into independent contracts with them, and they call them not their employees but their independent contractors. Here it is essential to take note of the fact that the definition of employer that has been given under the PoSH Act is a little wider from the definition given in other places in labor laws. So basically, if we talk about who is an employer under the PoSH Act, it does not it first of all in government cases it includes the head of the department. In private cases it includes any person who has the responsibility for the supervision and control of the workplace. So basically online aggregators such as Uber, Ola, Swiggy, etc., they are also going to be treated as employers, and they also have the responsibility to constitute ICC, and in order to ensure that no sexual harassment is taking place at their workplace. Now, P versus Union of India, it was stated that it is required that it is basically a time-bound exercise, and in this case it was made clear that it should be expedient, and no unnecessary lag should take place because they defeat the purpose of the act. In this case, the company was basically slapped with a fine of 1 lakh rupees. Now, there was a case in which the Industrial Tribunal issued PoSH guidelines to the IIT Delhi campus, in which it stated that they were required to install CCTV cameras in order to make sure that the women feel safe, and it acts as a basically deterrent effect to all the people who are the perpetrators of such activities. Now, more recently, Aureliano Fernandez versus the state of Goa. The Supreme Court also gave 10 guidelines which state that first of all, the Union of India, state government, etc., should carry out time-bound exercises in order to make sure that all these LCCs and ICCs have been duly constituted, especially with the state and the central government. Secondly, the Supreme Court stated that it is a work to ensure that necessary information is basically regarding the constitution and composition is available to the people who are working in the office. So essentially, even if ICC is constituted and the workmen, the women essentially are not even aware that the ICC exists, then it defeats the whole purpose. So the whole idea is to make it very easily reachable. So there should be IDs, phone numbers, etc. The names of the people who constitute the ICC should be given everywhere in the workplace, so that the woman has an idea of what to do and how to easily approach those persons in case any such thing happens. Then a similar exercise is to be undertaken by statutory bodies, again stating that statutory bodies and head of the professional, for example, in law there is Bar Council of India, in and others, accountants, cost accountants, lawyers, doctors, etc. So the head of the profession is going to ensure that these committees are being formed in their respective fields. Then immediate and effective steps are going to be taken for the authorities, management, employment to familiarize the members of ICCs with their duties, etc. Then there should be orientation programs that should be taking place, and the orientation program should be taking place not only for the ICC members but also for the others to undergo such trainings. Then it is the duty of the NALSA and the State Legal Service Authority, the National Legal Service Authority and the State Legal Service Authority, to constitute modules in order to ensure that the women don't undergo this kind of harassment. So the National Judicial Academy, the State Judicial Academies also are required to take these kind of exercise and ensure that these things are not taking places in the district courts and the sessions court and the lower court as well. Then it is the Supreme Court also said that that this judgment, this particular judgment of Aureliano Fernandez, should be transmitted to all the secretaries of the ministries of all the governments, so that they cannot later on say that they were not aware of these guidelines, and that is why there was a lackadaisical approach in the implementation of the guidelines. So basically, no stone left unturned. Then the Registry of the Supreme Court of India shall transmit a copy to the Judicial Academy, NALSA, and all the people who have been essentially named above in the guidelines. Then Member Secretary of NALSA is also requested to transmit a copy of judgment to these other people, state high courts, etc., registrar, the judges, the district court judges, etc. as well. Then the chairperson Bar Council of India and the apex body mentioned in basically in point number 9 to transmit a copy of this judgment to the state bar councils as well. So NALSA, the district courts, etc., are going to make sure that this thing essentially percolates down to the lowest level and it is implemented properly. Now, these guidelines all come in the light of the fact that it has been noticed that with respect to the ongoing wrestler protest, where there are 30 sports federations in India. Out of these 30, only 16 right now have ICCs and others do not even have ICCs. The local committee, the most of the unorganized basically most of the workforce works in the unorganized sector and who are required to approach to the LCCs, but there is no mechanism, no way that they can reach the same. And not even that, even in the government departments, the LCCs and the ICCs have not been constituted. So the idea is that the Supreme Court is taking a stronger stance in order to ensure that this is duly done and the workplaces are made safe for women. So thank you. This is all. I'm sorry. This is all for today. Thank you. If you have any doubts, you can always write in the comment box. See you again with another topic next week. Thank you.